When the Supreme Court overturned Roe v. Wade, it did more than just allow states to ban abortion. It showed how this court views rights not explicitly listed in the Constitution.
It's really difficult to exaggerate the importance of this decision. The court has pulled a complete 180, going from recognizing a constitutional right, an individual right, to saying 50 years later, no, we were mistaken.
Here's the legal reasoning behind that 180, and why, even though the court's opinion made clear it applies solely to abortion, some legal experts think the same methodology could be used to revise other rulings. The framers wrote the Bill of Rights, the amendments to the Constitution, to, well, list the rights Americans have. The right to free speech, to bear arms, to not have soldiers in your house during peacetime, you know them. And at some point, specifically at the 9th one, they wrapped it up by saying this list isn't exhaustive, and there are other rights not named here that cannot be denied or disparaged. Or, in 18th century terminology, the rights not in the enumeration.
So the Ninth Amendment is there essentially to say that there are unenumerated rights, right? That the list in the Bill of Rights at the time was not intended to be exclusive. And so then the difficult part becomes figuring out what those unenumerated rights are.
The Supreme Court has long seen the right to privacy as one. It established that right in cases involving raising children, that parents have the right to teach them another language or send them to private school, and in cases involving having children, that the government could not sterilize convicted criminals. And in the landmark 1965 case Griswold versus Connecticut, which was based on these earlier rulings that overturned a Connecticut ban on contraception. In the opinion, the Supreme Court ruled that marital privacy, even though not mentioned explicitly in the Constitution, is one of those unenumerated rights protected by the Ninth Amendment. And that right meant using birth control was a private decision and couldn't be banned by the state.
There was a lot of different kind of ideas of privacy that flowed from Griswold.
Cases that expanded the right to birth control, the right to same-sex relations, and eventually marriage were based on these cases that established privacy as an unenumerated right.
That was sort of a constellation of privacy interests that arose in that way.
The right to an abortion was one of those that was established based on these rulings.
The phrase in Roe v. Wade, it says that the right to privacy that was identified in Griswold is broad enough to encompass the decision to end an unwanted pregnancy.
The Roe opinion mentioned that right could also be found in another amendment, the 14th, which says no one shall be deprived of liberty without due process.
It says we believe that's based on the Liberty Clause of the 14th Amendment, or the Due Process Clause, another name for that clause. Roe is from tradition that looks at these concepts of liberty and equality very broadly. Okay, it applies them very broadly to new circumstances and to a society that is different than the society that we had in the 18th century.
But two of the justices thought that was too broad of an interpretation.
The dissenters in 1973 said that the Constitution is silent on this matter. It doesn't say anything about abortion one way or the other, and this court has no business interfering with the legislature's judgment about how to regulate a pregnancy. And that's pretty much the reasoning that the court has adopted now.
In overturning Roe, the court wrote that an unenumerated right should be deeply rooted in this nation's history and tradition, and ruled that the Constitution does not confer a right to abortion.
The methodology is called originalism, where you stick very closely to what you think the authors of the passage understood it to mean, what the public understood the passage to mean at the time it was adopted.
But some legal experts and civil rights activists are concerned about how this methodology could be applied to some of these other rulings involving privacy, like in Griswold or in Obergefell versus Hodges, which legalized same-sex marriage in 2015. But the majority wrote that those cases do not destroy potential life like abortion. They even wrote, nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. But the dissenters argued that even if the majority's word is trusted, that law has a way of evolving without regard to original intentions. And whatever today's majority might say, one thing really does lead to another.
This broader approach to applying the liberty concepts and equality concepts of the Constitution. The current majority of the Supreme Court is very skeptical of that. And that doesn't mean that they are eager necessarily to overrule those precedents. There are different conditions and different facts that apply to each of them. But as a matter of principle, yes, those would be on shaky ground. The idea that they would be overruled wholesale, the way that Roe versus Wade has been overruled, a little harder to imagine because the social acceptance is broader.
The court is certainly saying this is just about abortion, but there's a breadcrumb trail the court is leaving in the future if it wants to go further than abortion, and I don't think we can rule that out indefinitely.
Experts like Ziegler say there's no immediate prospect that these other rulings would be reversed. But the Supreme Court views unenumerated rights much differently than previous courts, and that may play out in future cases.